people who are not actually permanently living in the US and are using their green card as like a glorified tourist visa, these people should always have had problems re-entering the US. Customs officers were supposed to ask you, are you living in the US? Why did you spend so much time outside of the US? And now that's being pretty aggressively enforced. Hey guys, let's talk a little bit about some of the misinformation that's out there right now about immigration policies. And these mostly apply to permanent residents or people who are applying for permanent residence. I recently did a video on who should avoid applying for naturalization. And I mentioned people who have like a criminal history within the last 5 years are likely to be denied. And one of the people in the comments said something like, this is false, the lawyer's just trying to create fear to get more business. I got a DUI and I naturalized. But he also mentioned that his DUI was from a long time ago, which actually was consistent with what I had said in the video. Any conviction within the last 5 years is likely to impact your good character, and you might need to wait a little longer until you have 5 years of good character. When he posted this in the comments, there was like a whole discussion from various people regarding immigration policies that they believe are in effect, and a lot of them were not true. And also in my day-to-day consultations with clients, people regularly say stuff to me and I have to correct them and tell them it's not true. So that was actually the inspiration for today's video. The first thing is that permanent residents cannot travel right now. I know there are lawyers out there who are saying this. Some of them are also actually reputable attorneys, so I'm not gonna speak poorly about them. But I will just say, it hasn't been my experience that permanent residents cannot travel. Permanent residents who were previously inadmissible for crimes, which means they committed a crime that made them ineligible to return to the US if they ever leave. Sometimes customs officers didn't catch the fact that those crimes existed or were committed. And now they're finding out that, hey, this person was actually convicted of an inadmissible crime. So when that person now, after like 30 years, travels and re-enters, all the news headlines are like, permanent resident of 30 years or 50 years gets detained by ICE when they re-enter. Yeah, but they were actually inadmissible for a long period of time. It's just that we never previously caught it. So that was never a huge surprise to me. The other big thing is that permanent residents who are spending way too much time outside of the US, like sometimes a year continuously or more than 6 months, and they come back for short periods of time, leave again for 6 months, come back for short periods of time. People who are not actually permanently living in the US and are using their green card as like a glorified tourist visa, these people should always have had problems re-entering the US. Customs officers were supposed to ask you, are you living in the US? Why did you spend so much time outside of the US? And now that's being pretty aggressively enforced. But if you're a permanent resident and there was no problem or defect in the way you became a permanent resident, and you have no criminal history, and you just want to go on like a 3-week vacation abroad, I see no reason why you can't travel until I have a negative experience where customs harasses or denies entry to a permanent resident who has a really clean case like what I just described. I'm gonna keep telling people that they can travel as permanent residents as long as they continue to meet these requirements. Another big mistake that a lot of people are making and that I regularly have to correct, and you can see things like this in the comments of my videos, is that if your naturalization application for citizenship is denied, you'll be placed into removal proceedings. That's not necessarily true, and in fact, from my experience, most naturalization denials do not result in removal proceedings. There is a blanket statement out there that's something along the lines of, if USCIS denies your application, the next thing they're gonna do is place you into removal proceedings. That's true for some things. If they deny your adjustment of status application, a green card application, and you are otherwise unlawfully present in the US, the next thing that's gonna happen is you're gonna get a notice to appear in immigration court to initiate deportation proceedings. So that's totally true. And also, as of recently, If you file an I-130 for someone who entered the US without inspection or who's unlawfully present, there's a good chance even before there's a final decision on that I-130 that the person will be placed into removal proceedings. But I've seen people who have pending naturalization applications for citizenship who've consulted with me because they want me to withdraw their application. And then when I consult with them about it, turns out that they would definitely get their naturalization application approved. Like, I can't say 100%, but they have no criminal history, they have good character, they don't owe any overdue taxes, they've never falsely claimed to be a US citizen, they don't have any dependents who they're not supporting, their travel history is very limited, they didn't leave the US for more than 6 months within the last few years. And when I screen them, I ask them, why do you want to withdraw your application? Like, this should get approved. And I regularly hear things like, well, I heard that I could get detained when I show up to the interview, or I don't want to get placed into deportation proceedings. I have too much to lose. My spouse is here, my kids are here, my job is here, my whole life is here. I don't even know anyone in my home country anymore, and the thought of being detained or deported is just too much to bear. Please withdraw my application. And I have to oftentimes walk some of these clients off a ledge and explain the absolute worst thing that would happen in your case is they would deny the application, and that's that. They would not place you into deportation proceedings unless you're deportable. So if you have a criminal conviction for something that's referred to as an aggravated felony under immigration law, then yes, if you show up to your interview, you can be detained and placed into deportation proceedings. That's possible. But aggravated felonies are really serious, and you would have probably had problems before you applied for naturalization in most situations. Not always. You know, if you committed it long enough ago before the Department of Homeland Security reorganized after 9/11, in which case you need to speak to an immigration attorney before you submit any application. In fact, if you have any criminal history, speak to an immigration attorney before you apply for naturalization. Even if you're still going to file it yourself, at least get an opinion on what the likely consequences are. Even in cases where people improperly became permanent residents, like there was some defect, USCIS made a mistake by granting your permanent residence, whether they should have required a waiver or something else. When more than 5 years have passed since you become a permanent resident, it's very difficult, almost impossible for USCIS to rescind your permanent residence. So if you became a permanent resident through some defect and then you apply for naturalization, and I've seen a couple of these recently, like very recently, USCIS will deny the N-400, but that's the end of it. They don't take away your permanent residence. So anyway, this is a case-by-case determination. I'm not gonna just make blanket statements out there, but I will say, the vast majority of N-400 denials that I've seen have not resulted in removal proceedings. And it depends on the reason why it gets denied, but almost everyone, I would say 99%, there was one exception, of the people I've consulted with who are considering applying for naturalization, the worst thing that would have happened in 99% of these was their naturalization application would have been denied, and they would have lost their filing fees or whatever fees they paid to an attorney. Their permanent residency wouldn't have been at risk, but that's not necessarily true, so always speak to an attorney before you apply for naturalization. The third mistake I think a lot of people are making is believing that if they show up for an I-130 interview or adjustment of status interview with USCIS, there's a decent chance that they're going to be detained. So I focus my practice on marriage-based green cards. So if you marry a US citizen and you entered the US legally, I'm your guy. You can find my information in the video description below to schedule a consultation. I would be happy to speak to you or represent you in your immigration case. And a question I get by a lot of my clients who are doing marriage-based green cards is, how has the Trump administration changed this process? Is there a chance that my spouse, my immigrant spouse, is gonna get detained at this interview? And when the Trump administration first took power, there were a couple news reports out there about immigrants showing up to their USCIS interviews and getting detained. And USCIS actually issued a press release where they were like bragging about detaining a couple immigrants at their Miami field office. And there was no reason to do that other than to stoke fear in the hearts of the immigrant population who are trying to fix their status and become legal. But since then, people have been asking me, is there a chance I'll get detained at my green card interview? And If it's a clean case and you're applying for adjustment of status and you qualify for adjustment of status and you have no criminal history or history of immigration fraud, then I have no reason to believe you'll be detained. I focus my practice on these marriage-based cases, and since Trump took office, I haven't had any of my USCIS interviewees, people who've showed up to USCIS interviews, get detained. Now, there have been some close calls where I was a little bit concerned because the person had like a minor criminal history, not enough of a criminal history to trigger inadmissibility or removability, deportability from the United States. So I wasn't concerned. But in those cases, I did advise them, like, it might be a good idea to bring a lawyer with you just in the event that, you know, things go south. At least an attorney can submit a notice of representation directly to the ICE officer. And now USCIS has the power to arrest people without getting ICE involved. So it's going to be interesting to see how this dynamic changes what we're actually seeing happen on the ground at USCIS interviews. But my marriage-based green card applicants, at the very least, I have no reason to believe any of them will be detained when they show up to USCIS interviews. It is pretty rare. The situations where you see it happening are people who have criminal history or removal orders. Like, those are the two main situations. When I hear about someone getting detained, usually what I'm looking for is what crime were they convicted of or charged with. I've heard of some situations where people have been charged with like domestic violence, but there's no conviction and they still get detained by ICE. That tracks. That's probably accurate. And the second thing is, if you have a removal order, it's super risky to show up to a USCIS interview. So I have clients who need to file an I-130 petition to fix an old deportation order. And I've been telling them now's not the time, because if you show up to this interview, there's like a really high probability that you'll be detained. So we need to wait until these policies change to try to fix your old removal order. All right, guys. So just to summarize, things are really bad right now, like the worst I've ever seen them, but still not as bad as some people are claiming, and it's really fact specific. So if you're worried about your particular situation and you think there's a chance you might get detained and you want to see what an immigration lawyer has to say about it, or if what you're worried about is consistent with an immigration lawyer's experiences or recent experiences, my name is Puyan Darian. I'm an immigration attorney. I handle these cases nationwide. So if you want to talk to somebody, you could schedule a consultation with me. My information for booking a consult, the link is directly in the video description below, or you can go to my website, darianlaw.com. Thanks for watching, and I'll talk to you guys next time.